Is there ever an instance where an experienced trial attorney will selectively choose not to cross-examine an opposing witness and instead stand up and say, "Your Honor, no questions"? Is there ever that opportunity? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is yes. And that's true whether it's a medical malpractice trial or a wrongful death trial or even an accident trial. There are instances where an experienced trial attorney will now be given the opportunity to go ahead and begin his cross-examination. "Counselor, you can begin your cross-examination," the judge says. And now the attorney gets up, there's anticipation in the courtroom, everybody's expecting the attorney to go after this witness, hard-hitting, over and over, and to tear this witness to shreds. That's the anticipation. That's the expectation. That's what everybody assumes is going to happen. And now the attorney says very quietly, "Your Honor, no questions," and he sits back down. Everybody's shocked. What do you mean, no questions? How could he not cross-examine this witness? Well, you should know a little secret. Really good, experienced trial attorneys will selectively choose not to question a witness, an adverse, an opposing witness at certain times. Why is that? Because there are certain times when cross-examining a witness could come back to bite you in the butt. There are certain times that cross-examining a witness, an opposing witness, whether it's an expert or an eyewitness, could come back to hurt your case. Because you know that anything that you ask this witness, he's going to have an answer for, or the jury is going to feel very sympathetic for that particular witness. So let me give you an example. Let's say this is a medical malpractice case. Let's say the defense calls an 85-year-old woman to testify. And she's testifying about not a very important point, but something that's collateral, having nothing really to do with the key issues, but still important enough to call her to give some useful information. And now, she's asked some nice questions by the defense attorney. Everybody begins to like her. She's only on the witness stand 5 or 10 minutes. The jury likes her. She's such a sweet old lady. Do you think that your attorney is going to gain any benefit by standing up and yelling and screaming and trying to rip this woman's credibility to shreds, especially if she hasn't really hurt your particular case? The answer is no. You gain nothing by trying to attack this woman and her credibility. In fact, doing so may certainly harm your case and harm the attorney's credibility with the jury. We don't want the jury to feel sympathetic as if the attorney is beating up on this particular witness. Because all of a sudden, if they feel like she's being taken advantage of because she's a nice, sweet old lady, or that the attorney is trying to tear her apart left and right, they're going to feel really bad for her. And they're going to hate your attorney and your particular case. They're going to wonder, why is he doing this? She didn't say anything bad. She didn't say anything horrible. So you will find that some of the best trial attorneys in New York will selectively choose not to cross-examine a particular witness, especially if the witness has not hurt their case. So let's get back to the original question I asked. Are there instances where an attorney will choose not to cross-examine a witness? Yes, there are. It doesn't happen very often, but sometimes that is the best course of action to take if you find that the witness has not hurt you and you gain absolutely nothing by going after and trying to tear this witness apart when it serves no purpose because you don't want to just get up to show the jury that you're a good cross-examiner. That doesn't achieve anything. You should have a clear, definable goal for each and every witness that you go to stand up and begin cross-examination. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what happens in the minds of a trial attorney during the course of a medical malpractice trial, an accident trial, or even a wrongful death trial here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.